Hello, my name is Mercer Colley, and I'm one of the partners here at Colley Forsyth. This is what we call TikTok Tuesday. We have Facebook Friday and TikTok Tuesday, even though we're on both. The reason we do it that way is one is devoted to English, one is devoted to Spanish, but both are completely devoted to answering any questions that you might have for immigration. I'm a board certified immigration specialist here in North Carolina. So is Jordan Forsyth, will be on Friday. And we are joined both days by Raquel Fernandez, who is an associate. So, Raquel?
Thank you for having me, Attorney Mercer. I'm really excited to continue doing TikTok Tuesdays. And we have a question here from Juana King. And she says she has a U visa and she's had it for a year and 4 months. She got it for 4 years. How long does she have to wait? So she didn't ask completely, but maybe she's wondering how long she has to wait until she adjusts status.
Yeah. That's what we'll go with. So Wanda, what you have is a U visa. Like you said, a U visa is good for 4 years. The way the law is set up is that after you've been in U visa status for 3 years, you're eligible to file for a green card. So if right now, if you're at 1 year, 4 months, then you have about another year and 8 months that you have to wait before you're eligible to file for the green card. And then what will happen is when you file for it, your U visa will be automatically extended for a time period. So that way you won't go out of status while you're waiting for them to make a decision on your green card. So we're assuming that's what you meant by how long do I have to wait? But that's how long it is you have to wait 3 years, and for you that would be another year and 8 months, somewhere in there, that you'd have to wait.
Yep, and I did see a second comment from her where she did finish the question by saying that it would be an application for her residence. So I'm sure some people are having a little trouble fitting everything into one comment, which I totally understand. And we do our best to find the other comments that are added. I also have a question here from Dreamer1, and she asks, my husband has voluntary departure. We just sent the appeal. I'm a U.S. citizen. I'm his petitioner. And I don't see the rest of the question, but possibly asking about just voluntary departure process.
Sure. So start answering, and then if we're on the wrong track, just let us know that you had a different question. Voluntary departure, for those who don't know, is something that you can get from an immigration judge, which would allow you to leave the country on your own, not be deported. And also, if you do that, you do not have an order of removal against you. But typically what the judge will do is say you have to be out of the country within 120 days. Now, if you filed an appeal after you have voluntary departure, there could be different impacts on it. And so one impact could be if you're granted voluntary departure as part of, say, another application like asylum, you can appeal the asylum, and then at the end of that, the Board of Immigration Appeals could reinstate your voluntary departure. But typically, while it's at the Board of Immigration Appeals, you no longer have to depart until they finish their decision. Now, if your appeal was on the voluntary departure itself, then that may have a different issue. So we'd have to look at that. But if you appealed a different case and you're granted voluntary departure, that could still be put in place once the Board of Immigration Appeals makes their final decision. So it really just, it's going to vary, and it's going to depend on your particular case, what happened. But while an appeal is pending, your husband does not have to leave, because the voluntary departure is stayed, so it's put on hold until the board makes their decision.
And Attorney Mercer, she didn't add this, but I also wanted to see if we could address what would happen. She said she's his petitioner. So what would the process be like as she's petitioning him if he did have a voluntary departure before?
Sure. So if he had voluntary departure and did not leave, that could that could create some other things. Because what happens if you're granted voluntary departure and you're told you have to leave within 120 days, and on day 121 you haven't left, then that voluntary departure becomes an automatic order of removal. So it's possible that he would have an order of removal. Now, as a U.S. citizen, you still can apply and you still may be able to help him. But what happened at that point is that you'll do the first step. You'll file for him as a U.S. citizen spouse. That's called an I-130. Once that's approved, then you go into the second steps. And so if court is over, and voluntary departure is over, at that point, you're going to have to look at probably consular processing outside of the United States, which would mean having to file some waivers so your spouse can get back in the U.S. after everything has been decided. But there are a lot of different issues that we need to know about before I can say for certain. One would be, how did your husband or your spouse enter? Was it with or without a visa? And is the voluntary departure, is it final? And now it's a final order or not? But typically speaking, yes, there's going to be something you can do, but we're going to need more information. So that's a fairly complex situation. So my recommendation would be, you need to speak with an immigration attorney. And you may already have one if you're in a situation where you have voluntary departure and you're on appeal. That kind of sounds like something an attorney would do. So you may already have one. So you may want to run it past that attorney, or like I said, or actually, as Raquel said earlier, you can set up a consultation. We do free consultations, and we can review a case and let you know what we think.
Awesome. And we do have one final question here, and it's kind of similar to what we were just discussing. So Lolly asks, my uncle has deportation. Can his 21-year-old son help him get his documents?
So generally speaking, if a U.S. citizen child is now over the age of 21, they have the right to file for a parent. That's absolutely still the case. The problem that, kind of like the last question, I don't have enough information, because if his father entered without a visa, then he's going to run into some complications that is going to make it very difficult to get around. For one, you may have, like we speak about waivers a lot. So you're allowed to apply for a waiver if you have a qualifying relative. And so if you have somebody as a qualifying relative, they took the first step, they filed, and you're eligible to get a visa, but you have to go back to your home country to get it. If you leave and you have more than a year of unlawful presence, at that point, that's going to trigger a 10-year bar. The only way to get around that is with a waiver. And in order to get a waiver, that you have to have a relative that is qualifying. And unfortunately, a child is not a qualifying relative for this type of waiver. It'd have to be a spouse or a parent, and either one can be U.S. citizens or permanent residents, but it has to be a spouse or a parent. Now, if his father entered with a visa, then that puts him in a different category. And yes, at that point, there is a possibility that we would be able to help him. We'd have to see what that order of removal is about to see if we can get that case reopened. But yes, there is a way that we should be able to help him if he entered with a visa.
So if you guys have any additional questions, we do answer these questions generally speaking. So you guys can also set up a consultation if you have additional questions. And I know we didn't have time to get to all of the questions here, but I will save your questions for next week. And if you guys speak Spanish, let me know, and we can also address them on Friday for the Spanish Live with attorney Jordan Forsyth.
Okay, well, thank you, Raquel. And again, everyone, we try to keep everyone as informed as possible. So the best way to keep up to speed would be to follow us. And that could be on TikTok or on Facebook. And as soon as things start happening with either DACA or immigration reform or whatever the case may be, our first thing that we want to do is get it out to as many people as possible. And the best way to do that is either on Facebook or TikTok right now. So you follow us, we will keep you posted, and that way you also know when we go live, because that's when we'll be giving out new information.
Absolutely. Thank you so much, Attorney Mercer, for taking the time to answer so many great questions. And we'll see you back here next TikTok Tuesday at 12 o'clock.
Sounds good. Thanks, Raquel.
Okay, bye.
Bye.